Hello friends, today we are going to talk about a very important topic of legal provisions for senior citizens. Normally we talk about social aspects, economic aspects or health care for senior citizens, but legal aspects is something which is generally ignored. There are various laws in our country which provide for the rights of senior citizens, yet the unfortunate part is that most of the senior citizens themselves are not aware of it, and even lawyers and other persons are not aware of the rights of senior citizens. Due to this, despite the legal provisions being there, the senior citizens continue to suffer in silence. Before I start with my subject, I am going to tell you a small story. Some of you might have heard of Professor Lautika Sarkar. She is regarded as a doyen in the Indian legal history. She was the first lady who graduated from Cambridge University, and she had a house in Hoskas in Delhi. She did not have any children, and all of a sudden one winter evening she was found sitting outside her house with all her small gadgets and all she had. Somehow the media picked up the story, and then the matter was taken up. It was found that some years back somehow a gift deed had been got executed from her which she did not remember about, and the person to whom the property had been gifted threw her out of the house instead of taking care of her. Now, just because the media took up her case and the matter went before the tribunal, then ultimately the gift deed was set aside and she was restored to her home. The idea of highlighting this story is only to emphasize the fact that even a person who is a legal luminary herself was cheated in this manner. She was thrown out of her own house, whereas at her age she should have been in the house. She did not herself know that she could take recourse to law. It is only through some enlightened persons and because media highlighted the issue that she could be restored her house. We have heard of various other cases where senior citizens are subjected to violence within their home, either by their own children, by daughters-in-law or by strangers even. A lot of senior citizens end up in old age homes. As such, it becomes important that we should have some knowledge about the legal provisions which are available for senior citizens so that they can be helped to take benefit of the law which is there existing for them. In today's program, we are basically going to talk about some of the difficulties which are faced by the elderly. We are also going to understand the legal framework that supports the elderly in India and also the international efforts for the elderly. If we just look at the background, we would find that 1/8 of the world's elderly population lives in India. We know that India has a huge population, and if 1/8 of the world's elderly population is living in India, we can understand that the numbers would be huge. In fact, 8% of the population in India is above 60 years. So we can again understand that it's a huge number of persons we are talking about. Now, senior citizens can be regarded as constituting a class in themselves, and the other part is that they are not a homogeneous group. We find that amongst the senior citizens also there are differences based on age gap, level of physical and mental alertness, their ability to work and the like. Often you find that there would be difference between a senior citizen who is 60 years of age and somebody who is 80 years of age. Obviously, their mental alertness is different, their ability to do some work would be different, their dependence on others would be different. So, that is why it becomes important not to recognize senior citizens just as one class, but also to understand the differences that are there amongst them, and which would also lead to how the legal framework works for them. Again, the senior citizens constitute one of the most vulnerable sections of the society. Though all their life they have been working for their children and for the society, but at the fag ends of their life they are neglected by one and all. They are subjected to all kinds of abuse, physical, emotional, psychological, and are often regarded as a burden by the younger generations. We have come across a number of cases where the children abandon their parents, just leave them 40-50 kilometers away from their homes, and they find it extremely difficult to come back, as a result of which they might end up in old age homes or begging on the streets. So, it becomes important that we again look at the legal framework which is available for them. Again, they face various kinds of challenges: social, physical, mental, economic. We also see these days that there is a lot of a lot of children are leaving their homes either to go abroad for studies and work, or even from rural areas the children are moving to the urban areas. So, the senior citizens are left neglected. At the same time, the women face a double jeopardy because by being women they are vulnerable, and then additionally when they are senior citizens or they are widows, then they face more problems. Now, if you just look at the report of the National Crime Records Bureau, which is of 2016, there were 22,040 senior citizens who were victims of crime. This refers to only those senior citizens who were victim of a crime as has been defined under various laws, but there may be so many other senior citizens who have been subjected to different kinds of abuse and who may not have actually reported the cases. We also see senior citizens normally have a resistance to reporting cases when they are subjected to abuse by their own children, or then they feel that they would not be able to carry out the legal struggle, so they are scared to come to the court. So, as a result, a number of cases where senior citizens may be facing abuse do not get reported. Now, looking to all this, there has been a lot of discussion on what should be the rights of senior citizens, how they can be better protected, and here when we talk about rights of older persons, we are essentially referring to their entitlements. Internationally also, there has been a lot of discussion on this subject. The rights of the elderly are also recognized as fundamental rights, just as other citizens have fundamental rights. So, senior citizens also have fundamental rights, additionally being as senior citizens also. Unfortunately, again, as we have been talking about, due to high incidence of illiteracy and lack of awareness, a lot of times the older people in India are not aware about their rights, due to which they are not able to pursue the remedies which may be available for them in the court. The difficulties we have just looked at, but mostly it's health and care facilities. Either they are very expensive or they are not accessible to senior citizens. At times they may just remain at homes with no one to actually take them to the hospitals when they need urgent medical attention. Income and housing also becomes an issue because they may not have any sources of income, they may not have proper place to stay, so they might end up in old age homes or even on the streets. Social networking, at that age senior citizens feel the need to have someone around them, but we generally see that they remain isolated with no one to even talk to them. So, there are various concerns regarding senior citizens. Some of them have been tried to be addressed by the various laws that we have. Internationally, if we talk about the question of aging was first debated at the United Nations in 1948 at the initiative of Argentina. This was again raised in 1969. In 1971, the General Assembly asked the Secretary General to prepare a comprehensive report on the elderly and to suggest guidelines. Ultimately, in 1978, a conference was held on aging, and then again a conference was held in Vienna in 1982, and an international plan of action on aging was adopted. The overall goal of the plan was to strengthen the ability of individual countries to deal effectively with aging in their population, keeping in mind the special concerns and needs of the elderly. In 1992, the UN General Assembly adopted the proclamation to observe year 99 as the International Year of the Older Persons, and since then 1st October has been observed as the International Day for the Elderly, which is now referred to as the International Day of the Older Persons. In 1991, 18 principles were organized into 5 clusters, namely independence, participation, care, self-fulfillment and dignity of the older persons. So, we see that internationally also there has been a lot of concern for senior citizens, and as we look at these principles or the clusters, we find that there is emphasis on independence. No doubt senior citizens may be dependent on others for certain needs, but they should be able to live independently, be able to participate, and they should also have their dignity maintained. So, if we then look at the Indian perspective, we will find that even in the constitution, old age has been specifically referred to. Even before that, when we talk about fundamental rights, Article 21 talks about the right of every citizen to live with dignity, and quite obviously this would include the right of the senior citizens to also live with dignity. Article 41 of the constitution specifically obliges the state within the limits of its economic capacity and development to make effective provision for securing right to work, to education and to public assistance in cases of unemployment and also old age, sickness and disablement. So, we see that when we talk about rights of senior citizens, they also have a constitutional base. There are also entries in the state list and the concurrent list which talk about certain entitlements of senior citizens. The main issue which does come up for senior citizens is getting some kind of maintenance. Till the age of 60 they might be working. Even after 60 we do find that some of the senior citizens continue to work, but if they are not in a position to earn for themselves, question of maintenance becomes very important. Even if we do not consider the Senior Citizens Act, even prior to that there have been various laws which deal with entitlement of senior citizens or create provisions by which senior citizens or actually parents can claim maintenance. If we look at the Hindu law, as we all know in our country, basically your maintenance, your marriage, your personal issues are like governed by your personal laws. So, Hindus would be governed by the Hindu law, Muslims would be governed by their own law. Similarly, we have laws for Christians, Parsis and the others. So, when we talk about Hindu law, the obligation of the sons to maintain the parents who are not able to maintain themselves has been recognized since ancient times. You know, the whole concept of everybody wanting a son. So, it also emerges from this idea that the sons would maintain the parents. Now, the Hindu law as we know was codified in the early 1950s, and there are various provisions which entitle the parents to claim maintenance. The most important legislation in this respect is the Hindu Adoptions and Maintenance Act of 1956, as per which the parents can claim maintenance from the children if the parents are unable to maintain themselves. So, here it can be, what is important is that it is not only from the son, but maintenance can also be claimed from the daughter. The amount of maintenance would be at the discretion of the court. Parents would also include adoptive parents. If you look at the Muslim personal law, the Muslim personal law also has specific provisions. Now, children in easy circumstances, meaning children who can afford, they are bound to maintain their parents, while a son even in strained circumstances. So, a son cannot take the plea that I do not have the resources. Even if he is in strained circumstances, he is bound to maintain his mother if she is poor though not infirm. A son who is poor but earning something, again emphasis is that he should be earning something, is bound to maintain his father who earns nothing. A person is also bound to maintain his paternal and maternal grandfathers and grandmothers. Now, this is a provision which is available under Muslim law, that even the grandparents can be maintained by the children, whereas under the Hindu law we really did not have any such provision. Now, other than the personal law, we also have a general provision which has been included as part of Code of Criminal Procedure. So, that provides for maintenance. These provisions have existed even prior to 1900 in the earlier code which existed, and the Code of Criminal Procedure contains specific provisions by which, other than the wives and children, even the parents, here we are not really speaking of senior citizens, but we are generally talking about parents. The parents can seek maintenance from their children, again it could be daughter or son, if they are not able to maintain themselves and the children have neglected to maintain them. Even how the provisions are to be enforced is laid down in the law itself. Basically, an application has to be filed before the family court, or in some jurisdictions it may still be before the court of a magistrate, and then the court decides on the amount of maintenance. Earlier there was a cap of rupees 500 which has been done away with. So, any amount of maintenance can be claimed under these provisions. Now, this is a law which is applicable to everyone. Besides that, in 2005 a law was enacted which is the Protection of Women from Domestic Violence Act. This act is specifically available to women, so it would not be available to male senior citizens or to fathers and all, but it is available to women if they are subjected to any kind of domestic violence within the home. Now, a mother, she could file a case against her son where she could claim various reliefs under the act. She could claim maintenance, she could claim that she be not subjected to domestic violence, she could also seek a residence or even compensation if she has been subjected to domestic violence. Now, this is a very, very important legislation which can be used by women if they are being subjected to domestic violence within the home, and they actually do not want to go and report it to the police, yet they want to be protected within the home. Now, we come to a law which has been enacted specifically for the senior citizens. See, as I said, there are provisions which exist already for senior citizens. The general criminal law is also there. So, if a senior citizen is subjected to violence, they could get an FIR registered, but then we know that the process in the courts could be long drawn out. So, considering that senior citizens have specific needs which need to be addressed, the Maintenance and Welfare of Parents and Senior Citizens Act was enacted in 2007. Now again, it is relevant that we are not talking just about senior citizens, but we are also referring to parents. In fact, as we will just see, it also talks about grandparents. Now, under this law, there are various provisions which are beneficial for the senior citizens or even for the parents. The most important cluster which is available is regarding maintenance. Though as I just said, under the Hindu law, under the Muslim law, under Domestic Violence Act, also there are provisions for getting maintenance, but it was also felt that without having to approach the courts, there should be a mechanism available for senior citizens by which they can claim maintenance. So, we will also be talking about where the senior citizens can go under this act, but if we just look at who can apply under it, again as the name of the act itself suggests, it is not just the senior citizens, but even the parents, whether father or mother. It could be biological parents, it could be adoptive parents or even step parents. So, it is not confined to only the real parents as we use the term, but even the step parents could file a petition under an application under this law claiming maintenance. And it is also not necessary that the parent should be a senior citizen, they can still file the petition. A senior citizen is defined as somebody who has attained the age of 60 years. So, somebody who is 60 years or above is regarded as a senior citizen. So, they can also approach under this act. However, the important condition is that whoever approaches under this act, they should be unable to maintain themselves from their own earnings or the property which is owned by them. Against whom the application can be filed? Now, as I was mentioning earlier, this also incorporates a provision for grandparents. So, the parents or the grandparents can file the case against one or more of their children who is not a minor. So, case cannot be filed against a minor, but it can be filed against one or more children. It is at the discretion of the parents or the grandparents. However, there is also a provision that supposing one child has been impleaded as a party, then the other child may move an application for impleading the other children also as respondents in the petition. So, that then it would be up to the tribunal how it apportions the maintenance to be paid by them. Significantly, the difference this act makes compared to other laws and provisions which we have had earlier is that there was earlier really no provision for those senior citizens who did not have any children. So, in this case, it also makes a provision that a childless senior citizen can file a petition against any relative, again who is not a minor and has the sufficient means and is in possession of or would inherit his property after his death. Earlier, what used to happen, if a senior citizen who is childless would die, then the property would obviously go as per the law of succession to his legal heirs, who may not be his, who obviously he does not have children, but there was no liability on the relatives to maintain the senior citizens. Now, this act recognizes the liability even of the relatives who would inherit the property of a senior citizen to provide for maintenance. Significantly, it is not necessary that the property should only be immovable property like a house or a flat. It could be movable property, it could be ancestral or self-acquired property, it could be tangible or intangible. Now, who can make an application? The application can be made by a senior citizen or by a parent, as we are talking about. If he is incapable, then any other person or a voluntary organization authorized by the senior citizen can also move the application. Now, this is again significant because if a senior citizen is perhaps 70, 75, 80 not able to move out himself, then he can authorize any other person to move an application on his behalf. The tribunals which are constituted under the Act can also suo moto take up the matter. Suo moto basically means that if through somebody they come to know that a senior citizen needs maintenance, they do not have to wait for an application to be moved before them, they can take up the matter themselves and call the parties. Now, what can be claimed? Obviously, we are talking about maintenance, but maintenance should be such as makes provision for food, clothing, residence, medical attendance, treatment. So, all the basic necessities of a senior citizen would be covered within the amount of maintenance that is awarded. At present, the Act provides for a maximum cap of rupees 10,000. Certain amendments are in the offing to the Act, so the cap may be done away with, we do not know yet. However, at present, the maximum amount which can be claimed is rupees 10,000. Now, why this becomes significant is that in a particular case, if we feel that the senior citizen would need an amount maybe up to only 10,000, then it would obviously be beneficial to come under this law, because the proceedings under this are faster. But if we feel that a senior citizen needs a higher amount of maintenance, then it would perhaps be better to approach under section 125 of Code of Criminal Procedure, which we have just referred to earlier. Another important aspect is that the tribunal can also award interim maintenance. Though the applications are to be disposed of by tribunal speedily, yet during the interregnum, when the senior citizens are not getting any amount, the tribunal may even award interim maintenance. We also need to know where the case can be filed, because otherwise the senior citizens would be running from one place to the other. So, basically a case under this act for maintenance can be filed in any district where the parent or the senior citizen resides or last resided, or where the children or the relative, meaning the person against whom the case is being filed, resides. Okay, so it can be filed at any of these places. Now, if the children or the relative, that is the other party, do not appear despite service, then the tribunal may even decide the matter, what we call ex parte, that is in the absence of such persons. The law specifically provides for the mechanism or the structure where these cases are to be taken up. So, it envisages that in every district one or more tribunals may be set up in a subdivision basically for the purpose of adjudicating and deciding upon the order of maintenance. This tribunal is to be presided over by an officer not below the rank of a subdivisional officer. Now, the act also provides for setting up of an appellate tribunal. Sometimes the senior citizen or the parent may not be satisfied with the order which has been passed by the tribunal. In those cases, they can file what we call an appeal before the appellate tribunal, which is also to be set up in each district to hear the appeal, and it is to be presided over by an officer not below the rank of a district magistrate. Now, here it is the respondent, that is the children, they cannot file the appeal. The provision of appeal is specifically available for the parent or the senior citizen. Now, certain time limits have been given. The appeal has to be filed within 60 days from the date of the order passed by the tribunal. The tribunal is actually obligated to provide a copy of the order to the senior citizen or the parent and even the other party, and the other party has to deposit the amount within 30 days. If they do not do so, or the parent or the senior citizen is not satisfied, then an appeal can be filed within 60 days, and then it is the duty of the appellate tribunal to pass an order within 1 month of the receipt of the appeal. So, these time limits have been laid down so that there is speedy disposal of matters. Now, when we come back to the tribunal, when an application is filed before the tribunal may also refer the matter to a conciliation officer. The purpose is that, being a family matter, effort should first be made that there is amicable settlement between the parties through conciliation. If a settlement takes place, then accordingly an agreement is drawn up and the tribunal passes the order. But if there is no agreement, there is no settlement, then obviously the tribunal would proceed to adjudicate the matter. Now, while granting maintenance, the tribunal has to also look at certain things. It has to be satisfied that the children or relatives have neglected or refused to maintain a senior citizen, being unable to maintain himself. So, two things are necessary. The senior citizen should be unable to maintain himself. At the same time, the children or the relatives should have neglected or refused to maintain a senior citizen. If those conditions are not fulfilled, then the tribunal would not pass an order. While granting the amount of maintenance, the tribunal may also direct for simple interest to be paid. Now, if we just look at the procedure of the tribunal, we will find that it is a very simple procedure which is followed. It is more like an inquiry. It is not like a trial which takes place in a regular court. Obviously, principles of natural justice have to be followed. The other party has to be given a right to be heard. Obviously, if the other party is not appearing, as I said earlier, the other party can be proceeded ex parte. In their absence, matter can be decided. But if they are appearing before the tribunal, they have to be given a hearing also. Now, again for the tribunal, there is a time limit within which the order has to be passed, that is 90 days from service of notice on the other party. The tribunal, in given circumstances, may also extend the period by further 30 days. So, effectively at the most within 120 days of the service of notice on the other party, the tribunal is bound to pass an order. See, in courts we normally see that there may be delays due to various reasons, but here it is the orders are to be passed in a time bound manner, which is the greatest advantage of having this law. Another significant aspect is it's not that once an order is passed it remains forever. The tribunal also has been given the power to cancel the order, vary the order, alter the order. There may be change in circumstances. Sometimes it comes to the knowledge of the tribunal that the order was obtained by misrepresentation, there was some mistake of fact or whatever. In those circumstances, the tribunal may vary the order, or if there is some decision by a civil court, then also it may be varied. Before the tribunal, the lawyers cannot appear to represent senior citizens. So, the state government may designate maintenance officers who are normally the district social welfare officers. So, if a senior citizen needs some assistance, then a maintenance officer could be representing him before the tribunal. Now, the law does not just stop at passing of orders, it is also important that the orders are executed. Often we see that even in courts the orders are passed, but the other side, that is the children or the relatives, they may not be willing to comply with the orders or pay the maintenance. As per this act, within 30 days of the passing of the order, the other party has to deposit the maintenance amount. But if the other party does not do so, in those circumstances, and obviously it should be without sufficient cause, the tribunal is not without powers. The tribunal can issue a warrant for levying the amount due in the manner provided for levying fines. There is a definite procedure which is prescribed in the Code of Criminal Procedure by which fines can be taken, and similarly a warrant can be issued by the tribunal for levying the amount in the manner in which fines are taken, or a person could even be imprisoned. Now, this is a very strong power which the tribunal has, by which a person can even be sent to jail if he does not pay the amount of maintenance. Now, again here there is a time limit that this application has to be made within 3 months from the date on which it became due, and it can also be enforced in any place against the person where that person is. Now, it is not necessary that the order has been passed in district A, so it has to be enforced only in district A. If the person against whom it is to be enforced resides in district B, then the order can also be enforced in such a place. So, this is essentially about maintenance, but there are other significant provisions also. Even regarding maintenance, if there is a transfer of the property, the Act provides that the right to receive maintenance would also be enforceable against the transferee of property. So, now if the property has been transferred to someone and that person knew that the senior citizen has a right to claim maintenance, or then the transfer is without any consideration, in those circumstances the senior citizen has a right to receive maintenance from the transferee of the property, and however this right would not accrue where the transfer was for consideration and the transferee did not have any notice of the right. Now, a very important provision which is again a novelty if you look at this law is that if a senior citizen has transferred the property by way of a gift or otherwise, I would just refer back to the case of Lautika Sarkar, Professor Lautika Sarkar that I was referring to. There was a gift deed in that case, and there were certain conditions regarding maintenance and all, but she was thrown out. Now, here the law provides that if a senior citizen has transferred the property by way of gift or otherwise, and a condition has been put there that the transferee will provide for the basic amenities and basic physical needs of the senior citizen, but later on such transferee refuses or fails to provide for the same, then the senior citizen has to move an application before the tribunal, and the tribunal can then set aside the whatever gift deed or whatever document that has been created. It is called declaring it void, that is of no effect, and it would be considered as if that document was made by fraud, coercion or under influence. So, that is obviously at the option of the senior citizen. So, now the senior citizen would not have to approach a civil court, but by virtue of this law they can get that document declared as void. The Act also creates an offence. I was referring to earlier that there are instances where senior citizens are abandoned far away from their homes so that they cannot come back. So, if a person who has the care or protection of a senior citizen, then he abandons such a senior citizen, then it becomes an offence under the Act for which a person can be punished for a maximum period of 3 months, meaning being sent to jail for up to 3 months, or fine up to ₹5,000, or both. This provision becomes significant when we talk about protecting the life and property of senior citizens, and also would act as a measure to prevent their being abandoned. So this is mostly about when we talk about the Senior Citizens Act, which provisions are available specifically for senior citizens. The Act also has certain miscellaneous provisions like setting up of sufficient number of old age homes, ensuring healthcare facilities for senior citizens, and also having a comprehensive action plan to provide protection to the life and property of senior citizens. So these provisions generally talk about maintenance, but there are certain other laws also which indirectly would be of some benefit to the senior citizens. Some of the senior citizens could be suffering from some mental illnesses. In 2017, a new Mental Health Care Act was enacted. So that could also have implications for senior citizens. They could take benefit of that act. So if we just look at this Act of 2017, a mental illness has been defined as a substantial disorder of thinking, mood, perception, orientation, memory, etc., that impairs judgment, behavior. However, it does not include mental retardation. It could also include conditions associated with abuse of alcohol and drugs. So in these circumstances, if a senior citizen is also suffering from a mental illness, then he could also take the benefits which are available under the Mental Health Care Act. This act specifically talks about rights of persons with mental illness, including the right to confidentiality. It also contains two very significant provisions, which is that if a person apprehends that he may have a mental illness, then even before he gets a mental illness, he can issue what is called an advance directive, which is made to a person who is again not a minor in writing, and it can specify the way in which a person wants to be cared for or treated, or the way in which he does not want to be cared for or treated. He can also specify the individual or individuals whom he wants to be appointed as his nominated representative. Nominated representative is basically a person who would be acting on behalf of the senior citizen or the person with mental illness in such a way that the wishes of the person appointing him are given credence. So a person can even in advance decide how he wants to be treated in case he gets some mental illness, and who would be the person who would be taking care of him. Similarly, we also have an act which is called the Rights of Persons with Disabilities. Now, this act is also very significant. It was a new act was brought about in 2016. Some of the senior citizens may suffer from various illnesses. All of us are going to be senior citizens at some point of the time, or we may suffer from low vision, we may suffer from various kinds of other ailments. So, this act also talks about a person with disability, that is somebody who has long term physical, mental, intellectual or sensory impairment, and lays down rights of persons with disabilities. Most significantly, it places a duty on the government to ensure that persons with disabilities enjoy the right to equality, life with dignity and respect for his or her integrity equally with others. So, the rights which are enshrined under this Act, Disabilities Act of 2016, would also be available to a senior citizen if they suffer from any such disability. No person can be discriminated against simply on the ground of the disability. They have a right to live in community, and the government is also to take measures to protect them from being subjected to various kinds of abuse. Now, lastly, I would just talk about the Legal Services Authorities Act. When we talk about the entire legal framework, the question naturally arises that how would you approach the courts? Normally, senior citizens feel that we do not have the money to approach the courts. The legal process could be delayed, it could be lengthy, it could be costly. So, there is a law which is there which provides for legal aid, meaning a person can get a lawyer free of cost at the expense of the state for pursuing the case in the court. Obviously, as I said before, the tribunals, the lawyers cannot appear, but legal services authorities have created a structure of paralegal volunteers. So, even paralegal volunteers could be available who could assist senior citizens if they have to approach the tribunals. Otherwise, also senior citizens could always be taking legal aid to decide in which cases they need to approach a court, where they need to go to the tribunal, getting legal advice. So, whenever there is some legal remedy which a senior citizen requires, they need not be worried that they have to pay the expenses, but they could just go to the nearest legal services office, which could be in the district, which could be at the state level, or even online these services are available, and they would be entitled to free legal aid. Generally, a woman, a member of scheduled caste or scheduled tribe, a person who is in custody, a person with disability, any victim of mass disaster, industrial workman, and there are certain income criteria, all such persons are entitled to legal aid. Some of the states have also provided for senior citizens as a class by themselves. So, depending upon the income limit, senior citizens can get legal aid. There are various governmental protections also which are available. So, if we look at the governmental schemes, there are various schemes which have been provided for giving various benefits to senior citizens, such as pension schemes, then like monthly pensions which are given to widows and all those. So, if we look at the entire structure, there are various legal provisions which have been specially carved out for the benefit of senior citizens. Unfortunately, due to lack of awareness, due to illiteracy, the senior citizens are not able to take advantage of these provisions. That is why it becomes important that we make ourselves aware of these provisions. Thank you so much.